Welcome to the session Documenting Environmental Harm in Ukraine from Data to Evidence. The environmental damage caused by Russian invasion of Ukraine is one of the most well-documented in history. Firstly, because of the work of domestic NGOs, international NGOs, the Ministry of Environmental Protection and Natural Resources of Ukraine, State Environmental Inspectorate, and the Office of the Prosecutor General. And second, because of the emergence of new methods like citizen science and remote sensing. Despite this, some reports, for example by Zoe and CEOPS, find that data is and will continue to be collected in isolation or only for very specific purposes, depending on the aims and interests of the stakeholder. Collection of physical data in the field remains quite limited because of the lack of access, lack of capacity of laboratories, for example, and resource constraints. Questions also remain about which incidents can be prioritized over others, and for data collection, and for example, how legacy contamination can be distinguished from conflict pollution, and how remote data can inform field data. In the end, any data must be defensible. Data should be collected to recognize international standards, with the aim of it eventually being an integral part of the aid register of damage, or part of other civil and criminal legal proceedings on the international and national level. So today we're going to discuss these issues of data collection and how data could move into evidence. We have a fantastic lineup of speakers, which I'll just briefly introduce. So first and foremost, we have Dr. Iryna Nikolaieva. She's a Kiev-based environmental expert, auditor, and author of methodologies for environmental research. Iryna holds a PhD in environmental safety, and her expertise mainly lies in assessing the environmental safety of hazardous industrial facilities within the framework of projects of international organizations. She has 20 years of professional experience, and her career consists of practical research according to Ukrainian legislation and European law. Over the last 2 years of work, she has devoted to studying the environmental impacts of military actions in Ukraine as a consultant to the Dutch organization PAX. Then we have Professor Cymie Payne, and she is a member of the Rutgers University faculty in New Jersey, USA. She participated as a counsel for the United Nations Compensation Commission in the first international reparations for environmental damage due to armed conflicts, and in the creation of a related environmental awards oversight program to ensure that awards were used to restore the environmental harm. She's the editor with Peter Sand of Gulf War Reparations and the UN Compensation Commission, Environmental Liability, published by Oxford in 2011. And she has also acted as a legal counsel before the International Tribunal of the Law of the Sea, for the Law of the Sea, including leading the IUCN team in the recent climate change advisory opinion case, and as an expert together with Robert Unsworth on environmental reparations in the case certain activities Costa Rica versus Nicaragua before the International Court of Justice. Finally, Robert Unsworth, Bob Unsworth, is a former president and current principal with Industrial and Economics Incorporated in Cambridge, Massachusetts. Mr. Unsworth has served as an expert witness in claims involving environmental and cultural damage caused by wildland fire, groundwater contamination, water use conflicts, legacy hazardous waste releases, and illegal ecosystem alteration. He co-authored with Professor Cymie Payne an expert opinion submitted to the International Court of Justice on ecological damages in the matter of Costa Rica versus Nicaragua. That case defined best practices in the economics of environmental damage assessment. He also assisted the UNCT which was created in 1991 by the UN Security Council with a mandate to process claims and pay compensation for losses and damages suffered as a direct result of Iraq's unlawful invasion and occupation of Kuwait, and in the identification and review of available methods for evaluating environmental damage. So first of all, I would like to invite Iryna and Nikolaieva to give a short presentation. The floor is yours.
Yeah, thank you. Thank you, all of you, for coming here today. I will speak today from my experience with working on military incidents with PACs. I joined PACs in 2022, and we started to collect this data on military incident with possible environmental impact. When we collected this data, we made analysis and prioritized our direction of the work. It was a lot of attacks on energy infrastructure, on oil and gas infrastructure, and at agrarian sector of Ukraine. So we did these studies also in response to the explosion of the dam of Kakhovka hydropower plant. One more study, and the most recent research was dedicated to the use of explosive weapons in populated areas. And of course, it was focused on environmental impact. That is the main I think areas where we can look at the environmental risks. So I will build the base for today's discussion to share with you how environmental damage during the war looked like. First of all, it's pollution to the environment, because the use of explosive weapons is resulted in releasing of hazardous substances and accumulation a big amount of waste, and all these substances not supposed to be in the environment, and it's when it's releasing into air or into water, it became toxin. So this is type of environmental risk that we are trying to identify during our researches. Also, I'm sorry, I'm a little bit sick. One more type of environmental damage is the destruction of the ecosystems, when we can see the loss of biodiversity and habitats, especially when it comes to the massive floodings, forest fires. Also, according to our governmental data, the 30% of the Ukraine is mine territories. So that's all is our area of environmental investigation. Also, we focused on the following health risks. We create the toxicological profile of targeted site and can determine the health effects. In our work, we use OSINT methods to identify, we both mentioned it, environmental risks. And my message is simple, where it can be helpful to get the evidence of environmental damage. We can identify, so it's a full process of verification of military incidents with environmental consequences. We can identify where is the place of military incident by geolocating and by using the satellite imagery. Then by analyzing open sources, we can determine which hazardous substances were stored in this place. So this way we can map environmental risks, like kind of environmental hotspots. What we cannot answer is what area of pollution, and we cannot answer the question what level of pollution, so where substances migrated and accumulated. For this, we need to go to the field works, we need to assess incident place, have access to incident place, and have this type of damage assessment methods. Here is an example from our research. It's a mapping of environmental damage to agrarian sector. You can see on the picture a real photo from place of incidents, and then we found satellite imagery high resolution to confirm. So this is step-by-step verification, and then it goes to the verified, it goes to the map. My conclusion is just that our remote sensing monitoring can be useful for areas where we don't have access, especially on occupied areas. It could be helpful for remediation purpose, for decision makers, for strategical planning, but we also see that collected data is not equal to evidence. For evidence, we need to have like much more work, especially access to the place, to do samplings, etc. will not repeat it. So the issue now for single repository collected, we have a lot of data from different organizations, governmental, non-governmental. We need to store it somewhere and to think about archiving issues. And we need requirements to evidence-based, which parameters should be collected to have like clear proof that this damage is happening. Thank you very much for your attention.
Swap. Okay, well, thank you, Frick, and thank you to the organizers also of this whole conference. It's a wonderful opportunity to engage this conversation. So colleagues, when we speak of evidence, we imply litigation. I think it's important to remember that if our primary concern is to restore the environment, we may be looking for different things than if we're thinking about entering into a legal process. So from the perspective of a lawyer, I'd like to share with you some of the demands that litigation makes on both parties with respect to evidence. And my comments will, I hope, explain some of the concerns of the judges who will ultimately decide cases that may appear. I think one of the things that can be very frustrating is that in reality, although the news is saturated with images of the war's destruction that we've all seen, in court, each step of the legal process has to be followed, and the injured party has the responsibility to demonstrate their injury and its cause with adequate evidence. So the legitimacy of the legal process depends on this, and the judges are mindful of that fact. I want to start, therefore, with an example and a question. So the UN Compensation Commission, which dealt with war reparations from the 1990 to 1991 Gulf War, environmental claims in particular, there were 168 claims, about $85 billion of damage was claimed, about $5.3 billion was awarded and paid. So about 6.2% of the total amount claimed was actually awarded. And so why 6.2%? And the photographs here is the oil spill on the left. That's oil on the water of the Gulf and the near shore. And on the right, the oil well fires were a couple of the most significant elements of damage. So evidentiary issues before a court include a lot of things. And I'll just, out of this longer list, I'll pick out a couple. An important one is the question of the standard of proof. So for each legal context, the type of evidence and the amount of evidence required to prove each element of the plaintiff's or the prosecution's case may vary between civil and criminal cases. It'll depend on the court, and it'll depend on the underlying laws that govern that process, that are applicable to that process, such as the rules that were expressed in the International Law Commission's draft rules and principles in the protection of the environment in relation to armed conflict that you heard about this morning from Dr. Leta. The claimant has to present proof of each element of their case. So for the UN Compensation Commission, those elements were showing direct loss, damage, or injury, including quantification of damage, baseline conditions before the conflict, and current conditions. They had to show that the harm was caused by the war, by the invasion and occupation, not by other causes such as overgrazing or industrial uses. And they had to show the basis for the claimant's evaluation of loss, damage, or injury. The evidence has to be relevant, it has to be admissible, which will depend on technical rules of procedure for the court. It has to be sufficient, and it has to be credible. And I will, in the next slide, start to suggest this question of what is sufficient evidence. So there are essentially 4 different kinds of fora in which claims could be heard. They can be civil or criminal, they can be national or international. And I've highlighted here the 2 processes that we actually have, along with identifying other processes that might also exist. So here in The Hague, fairly recently, a register of damage for Ukraine was established. And that's very comparable to the UN Compensation Commission that you've heard us mentioning, except for the fact that it only allows for presenting claims. There's currently no compensation fund and no adjudicatory process. So it's like the first stage of that, should the rest of it become possible. The other process, well, just for order, the other international process that could happen is the International Criminal Court, also in The Hague, but we don't have any indication that there'll be claims there for the environment as of yet. However, in Ukraine, the Office of the Prosecutor General has the potential and is in the process of developing prosecutions for environmental harm. The evidentiary standard for each of these bodies is somewhat different. So the UN Compensation Commission, you can see what was required. This is a quotation from the rules of procedure: documentary and other appropriate evidence sufficient to demonstrate the circumstances and amount of the claimed loss. Okay, in a common law setting, we would say that's more likely than not, or sort of more than 50% certainty on the part of the decision maker that this thing happened. In the Ukrainian law, it's called interconviction. That's a more common standard in civil law. So those of you from civil law systems will be familiar with that. However, in criminal law, in civil law, the consequences, the remedy is reparations, restoration, payment of financial compensation. In a criminal context, you're taking away someone's liberty, and it's considered more serious. So the standard is beyond a reasonable doubt, more than 90% certainty. There's certainly different perspectives that the claimants and the respondents have. And the claimants will be concerned about restoring the environment to the condition in which it would have been if the invasion hadn't occurred. But for the respondents, even if they accept that responsibility, they will want to be sure that they're not paying for anything that they didn't cause. So there's a lot of pushback. You have to remember that in a court, there will be, if there's due process, there will be a response. So why the 6.2% for the UN Compensation Commission? In this context of needing to come up with sufficient, relevant, admissible evidence, there were a number of problems. Lack of baseline information. What were the conditions before the conflict? Insufficient evidence about the harm. That is the kind of study that Iryna referred to that needs to be done so that the court can actually understand what the incremental change is. Insufficient evidence of causation by the conflict, really showing that link that this happened because of the conflict. And sometimes inflated claims, unnecessarily expensive restoration technologies, for instance. Less often, but still sometimes, other reasons such as contributory negligence by the parties. So I'll leave it there in hopes that this will provide a bit of a provocation and turn it over to my colleague, Bob Unsworth.
Thank you very much.
Morning. And you may be wondering why an economist is presenting on here at all. My expertise is on development and review of claims in an objective manner resulting from harms to the environment. And I've had the privilege to work with Cymie and others on a number of claims involving acts of war, including historical residuals of war, such as Los Alamos's impacts on indigenous populations in New Mexico. As Cymie implied, there are a variety of contexts in which you want to develop a claim, you want to monetize that claim. They can be political, both good and bad. It could be done for advocacy purposes, such as seeking funding for restoration of the environment. And you want to be able to convince funders that something is necessary and resulted from the harm. Or they could be in terms of civil or criminal liability determination. And the goal in all these cases is to convince a trier of fact that the evidence is sufficient, and the trier of facts can vary. And that would seem simple, except often in this context, the triers of fact don't tell us in advance what they think the necessary standards will be. And they're going to bring to their to the adjudication, a variety of perspectives and their own opinions, as we found out in Costa Rica versus Nicaragua, where if you go read that opinion, the court actually took two estimates and then determined what they thought the damages were on their own, which was horrifying as an economist, practicing economist, that they would do that, but is obviously common in the law. But within, despite the fact that we don't know what those standards are going to be, we can answer certain questions, hopefully, which is, what do we believe will be recoverable under the cause of action? Whether we'll be able to define that the harms occurred to the actions of the defendant in the case. And so we actually might have to get into issues such as whether or not environmental harms resulted from offensive actions as opposed to defensive actions. And determining, as we did in Nicaragua, Costa Rica versus Nicaragua, what are accepted approaches within science to bring to the court and try to encourage the court to consider standard approaches within science. And the last bullet point here that I think is important is that within most areas of the law in terms of compensation, there is a consideration of disproportionality. And so, as Cymie implied, if you propose a solution that's novel or exceptionally expensive, that may not be accepted by the court, and you may lose your compensation claim in that manner. As an economist, I think most folks come to the table with a preconceived notion of what types of damages would be accepted by triers of fact. In fact, as you can see from all the bullet points here, there's an enormous range of accepted methodologies within economics. There is diminution in market value. This would include, for example, agricultural land that's no longer usable due to anti-personnel mines, loss of harvestable trees due to loss of forest land. There can be increased costs to the public for drinking water treatment, remediation of soils, but then there also can be national economic implications, long-term reductions in GDP or losses in tax revenues, measures of social welfare. So this would be things like monetizing the fact that enormous opportunities for recreation and other experiences can no longer be undertaken in national parks that have been harmed. There's ecosystem service valuation approaches, restoration costs, which is what I argued in Costa Rica versus Nicaragua was the correct approach. And then finally, human health impacts, and there are a variety of ways of monetizing both morbidity and mortality. So the point at the bottom there is the most important, that we're not likely to know in advance what measures are going to be acceptable within any framework. And so we want to gather the physical evidence and the historical evidence to support any one of these, depending on whether they're going to be available. I should also mention that within some statutes, there are also penalty systems, which typically aren't based on any evaluation of the harm, but are more based on just unit penalties that are established within the law, much like a speeding ticket. So in this case, the scope and scale of the harm is overwhelming, and there will have to be decisions about which harms are recoverable and are worth recovering, and choices will have to be made, even if we're well aware of what methodologies are allowed and what causes of action are allowed. I think when you're talking about this geographic scale, I think statistics are going to matter a lot. I don't think it would be impossible to convince triers of fact that you looked at a sampling methodology across the landscape and assessed in detail harms at given locations, and then use statistics to model those up to the full scale of harm. And as already been mentioned, there are going to be serious challenges of access to areas when you have a long-running conflict. Data start to disappear, individuals with knowledge of the harms begin to disappear, and that makes it difficult to determine things like baseline. We're going to talk a little bit about remote sensing, I think, in the questions we have, but that would include use of historical imagery, and we have reasonably good historical imagery going back about 20 years in the case of the Ukraine conflict. So what would be my thoughts on enhancing the recoverability of claim? Evidence preservation, as has already been said, we need to establish places to keep all this information, and it needs to be stored in a way that it includes all the metadata. So if photos are presented as evidence, you're going to need to know the day that those photos were taken. You're going to need to know the geographic place. I'm a big fan of walking around with a GPS unit if you're taking photos. And before you take the photo, you take a picture of the GPS unit to prove you were there. You know which direction you're facing. You take the photo. It's very painful in the field to do that, but the value of that evidence is so much greater because, and I think related to that, there is a sense of weight of evidence. So if individuals are submitting photos or other evidence, such as citizen science, if you can provide some record of where the photos were taken, if they're using their iPhone and it had a location on it, those things all help. They may not be perfect, but it does give you a weight of evidence. I think in terms of chemistry, using split samples. Ukraine already has a problem with the number of samples and lab capacity, but it's still important to use split samples and send some of the chemistry out of the country to prove that the records are sound. Defining chain of custody. And then finally, if you're using remote sensing, doing ground truthing, which doesn't mean you need to go everywhere. It just means that from a statistical sense, you need to go to enough places to prove that the harm you asserted based on the imagery, in fact, occurred. And then identifying keepers of records and experts, as I said, before they go on to other careers or retire. And in this case, given the industrial baseline, understanding what the area would have been, but for the conflict is going to be important.
Thank you all very much for your presentations. Thank you both. Yeah, we've seen a wide range of perspectives on data collection, from practitioner and environmental safety experts to lawyer's perspective and the economist perspective. So I have a few questions to the panel, and after those questions, I will open up the floor for the audience if you have any further questions. So I would like to start with a kind of broad question, like given the sheer scope of the environmental damage across major reserves, urban environments, and industrial sectors, but also the involvement of many different stakeholders in the collection of data, what is in your minds, first of all, the greatest challenge to assessing environmental damage? And second, the greatest challenge in which incidents to prioritize for evidence collection over others? And this is a question to all panelists. Iryna, maybe you'd like to start.
In this respect, I think I would like to highlight the challenge of duplication of collected data. That's, I think, the main thing. Who will be a holder of all database on the military incidents for environmental damage, and who should do this cross-check. It's a pretty time-consuming, from my experience, to verify all data and to check duplication. So this is that somebody should take obligation and to have like this type of work, and of course the archivation of data, which parameters should be stored, which for example, from our experience, we need to store even all data sources. Sometimes it's for one incident more than 10, 20 data sources when you do your cross-checking. So to prove, to have a proof during, if we are talking about claims to get the compensation for environmental damage, it should be not duplicated. Also, I'm thinking about the approach of which approach we should choose to claim the environmental compensation. Should it be a kind of case-by-case approach, or kind of ecosystem approach? Because here can be duplication. For example, if we see oil pollution in one of the city of Ukraine, and then this enterprise can climb, or then a governmental authority can climb for air pollution, for example, and it would be duplication. So this is also the issue to think about.
Who would like to?
I think in terms of the way I think about it, unfortunately, is that in order to be successful with a claim, which is to recover either a force in action to remediate the situation or recover the dollar damages, we have an adage that says if you can count it, we can value it, but I bet you can't count it. So we have that problem. And the other adage is, we can definitely measure the loss, but the court's not going to accept it. And so I think probably the biggest challenge is in some regards is disappointment. The public has a sense that this is obvious, that the harm is obvious and it's massive. But proving that and distinguishing it from baseline and distinguishing potentially offensive actions versus defensive actions and who's responsible can be very difficult. One of the things we've encountered in cases involving military conflicts is getting records of where the military was and what actions occurred at a given time to prove that it actually had something to do with individual parties' actions. So.
It's been very far. That's okay, let's stay there, because otherwise we'll keep moving. That's all right, I'll speak a little loudly. I actually would like to first mention that our convener, whose name I'm gonna say because I'm gonna give you a citation, did a very useful paper that relates to this. So Frank van der Vet, A Polluting War, Risk Experts and the Politics of Monitoring Wartime Environmental Harm in Eastern Ukraine. And it was published this year in EPC: Politics in Space. I strongly recommend it, and I meant to put it in my slides. But I'd say sort of wholly agreeing with my colleagues on these very important issues. I'll add one, which is that over time, the environmental damage changes. Here we still have a conflict that's ongoing, but even if the conflict were stopped, by the time you get to the legal cases, things will have changed. And so there's a need to recognize the requirement to have ongoing assessment that will be contemporaneous with the court's review. With the UNCC, it was really 10 years later, and a whole suite of monitoring and assessment claims had to be addressed and awarded to collect the current information about the state of the environment. So yet another complication. But I think the kind of mapping that Iryna's initial intervention in response to this question implied is one of the solutions to. So that kind of systematic analysis and coordination of the information would be enormously.
Thank you very much. I actually have a follow-up question to what Bob just mentioned about disappointing the public in a way. This is something Iryna and I talked about yesterday a bit. Like, if you have irrecoverable damage, can it be compensated at all? And if not, why not?
Yeah, I think to be overly pragmatic,
yeah.
I always suggest that analyses start with market-based harms.
Mm-hmm.
So if it's going to cost money to clean up groundwater to use it as a resource, that's what you start with. I think in terms of lost resources, putting economic values on those, that's what I was trained to do. That's my core of what I do, and I would be pessimistic about the ability to recover it in a court of law, unfortunately. So I think that the damages in this instance are going to be so substantive. I don't know if you have to get to those categories at all, and that's purely pragmatic. That's not based on what's right or just. So no.
Can I ask you, Bob, a question? But can you elaborate when you say market values? I mean, what comes to mind to me is timber, crops, things that have sort of trade in market, but there's also the cost of recovery, which is a kind of market value. Can you clarify?
Yeah, so by that, what we mean as economists is that the cost of now having to treat water that previously didn't really require much treatment shifts not only the supply of it, but it also shifts the price. And so it's more expensive to consume it, and that has a real effect on the public. A non-market effect would be beaches are oiled due to the conflict, and folks may have a concern for the biota that live on those beaches, and there's ways to value those changes, but they're not observable in markets, and it's very difficult to elicit from the public their willingness to pay to have avoided something that clearly was unjust. You can't just ask them how much money you would have accepted to have the beach oil, and so that's where the challenge goes. But there's obviously a large volume of claims that don't require those types of methodologies that are. I think also that when you're talking about the cleanup costs, especially as it relates to soils, there is going to be an argument about whether it's worth it. Agricultural land is invaluable from a social perspective. It's not invaluable from an economic perspective, and so abandonment of the land may be, in fact, less expensive than trying to clean up all the soil from, chemical contamination. And you have to argue that it's worth it.
Which in the case of agrarian soils in Crane may be a very strong argument. If the market value of the land is based on some exogenous system like the tax system, then, and yet this is the source of food for not just Ukraine, but for other parts of the world.
Yeah, and I think you can frame the not only the physical harm, but the economic harm in the context of food security, and in the context of communal culture. Farming communities are different places than urban communities, and you want to perpetuate that culture. That's, but now you're into hoping that the trier of fact is listening and places some weight on that. So.
Of course, the conflict, the war is still ongoing. So, in your perspective, can environmental damage claims already be adjudicated while the conflict is still ongoing, or is the difficulty of obtaining evidence somehow prohibitive?
This is, I think it's a good question since we don't see an end to this conflict in sight. I'd say two things. One is there may be some instances that clearly the harm, it can be isolated from the ongoing conflict, and it may be worth pursuing that to get some results to begin with. That would be a certain kind of prioritization of a particular kind of claim and a particular forum. Processes like the Register of Damage for Ukraine is likely to be a very long-term process. And so beginning to determine how those claims will be, how environmental claims will be accepted, characterized, what the legal framework is legal work that can begin now and then prepare the way for eventual adjudication.
Yeah, I wonder to some extent. I mean, in the U.S., under tort law, there's this concept of bellwether cases, and so you might have a large number of plaintiffs who have similar harms, and you pick a few. You pick a few of those claims and you run them through court and let the trier of fact make a ruling on those, and then based on that, the parties then have an understanding of how these claims are going to turn out. But also, you have a better sense of how the court is going to consider them. I think there may be value here in picking a few claims and adjudicating them and proving it can be done, and then moving on from there. That also might help with funding because it proves that it has a purpose.
I would like to move on to what you just mentioned about earlier in your presentation about remote sensing. So you had a question about, can remote sensing data be used in contested compensation hearings? And next to Iryna, do you see any limitations to remote sensing methods in general?
I think that I have already mentioned it, the limitation, there is like no possibility to determine the amount of hazardous substances. Like it's very important to prove this environmental damage, not just that it's happened, it's clear from satellite imagery, it's evidence like that it's happened. But to calculate the monetary equivalent, we need to have like all data on amount, etc. So it's limited only by this means. And of course, to receive compensation, we need to have kind of clear mathematical model to transform from this harmful impact to financial picture. So yeah, it is limited somehow, but also I think that remote sensing should be used as a good ground to build and to further develop the evidence base for each case.
Yeah, I completely agree. If you're talking chemistry, there's a limit to remote sensing. There is a practice of remote sensing that detects change based on vegetative cover. And so sometimes we can actually, for example, in oil spills, have a sense of the extent of harm based on changes in cover. But I think the other thing that's left out of the remote sensing is courts generally want to set an idea of how confident you are in your estimate. And so there are a lot of good statistical techniques that allow you to, using ground truthing, to prove up how confident you are in your results. So if you're talking forest loss, for example, or if you're talking extent of beach oiling, if you have some data, you can calibrate your model to say, here's my estimate plus or minus 20% or plus or minus 50%. And courts like that, even if those ranges are large, they like the fact that you have some degree of confidence in your estimate.
Before I continue, we have a little bit over half an hour left, so I would like to open the floor. Please introduce yourself briefly and tell me to which panelist you're directing first.
Thank you. Thomas Hansen at Universidad Carlos in Madrid. Really interesting presentations. I got a pretty specific question, which is about some of the presentations. I think especially maybe yours, Cymie, speaks to like the ongoing investigations in Ukraine. And I would be curious to hear if any of the panelists have information about this, to what extent do these investigations cite, or do they refer specifically to ecocide legislation in Ukraine, or to what extent are they sort of broader environmental crimes that are in the mass so that's one thing. And the other is there have been some reports over time that ICC prosecutors were also at least assessing environmental crimes in Ukraine. So I was wondering if any of the panelists have any information on what might be the status of those investigations.
Let's collect a couple more. Yes.
Hi everyone, my name is Maricia. I'm a colleague of Iryna doing remote sensing work at Rutgers. And I was at a conference last week actually on environmental crimes at the European Space Agency, so really using remote sensing for gathering evidence on environmental crimes. And there somebody told me that when civil society actors gather a lot of evidence on harm to the environment and other things, that they actually kind of lose their protection under international environmental law, definitely if they provide intelligence on like location of military actors, because that could be used for military actions afterwards. So I was wondering how true that is, that they then become rather kind of like a military actor themselves instead of like being protected as a civilian under environmental humanitarian law. And if that is true, how do we ensure that we protect actually civilians that try to monitor these damages and then can help us in setting up evidence for these claims?
Thank you. One more, maybe? Yes.
Yes, Owen Derbyshire from the Conflict and Environment Observatory. I think this is maybe more clarification from Bob, and maybe touches on the bellwether cases that you were talking about. But in terms of building up the statistics, the court cases, were you suggesting one approach could be let's say if we use the picture that Iryna had on the screen as an example, that explosion at a fertilizer storage site, if you went to one of those sites, took all the ground data, could marry it up with the remote sensing and the social media stuff, you could build a case of exactly what happened there. But you also know something similar happened 10 other different locations. But you could refer back to those 10 other locations from the one that is well characterized as 11 sites, and that would be treated as 11. Is that what you were kind of getting at?
Thank you. Who would like to start?
Sort of take it in order right now. Sorry. So as I understand the question about the Ukrainian ecocide statute, I can't speak to what the Ukrainian government may be doing in preparing cases on that. On the International Criminal Court, that I can speak to partly because we were at the court yesterday and asked them, and so you may know that the prosecutor had invited comments fairly recently for the development of a policy document on how to address environmental claims or environmental crimes under the Rome Statute. And I provided a comment, as others here I'm sure did, as Bob's firm did. So what we were told is that they have a working group that is currently reviewing that process, what they received, and there was not a definite timeline that could be shared about the result of that. I think I'm going to add my own speculation to that, which is that it will be some time before the International Criminal Court decides whether or not war crimes can be tried. And I would even add a further speculation that it's possible that the national process in Ukraine may influence that decision. And this may go back to the concept of bellwether cases, sort of we need, because, and it's worth making clear, I think, that the UN Compensation Commission was the first international war reparations for environmental damage that had been done, really looking not at timber loss or, you know, someone took the cattle and the horses like we saw in World War I, but really looking at environment as such. We have not seen that in international criminal law at all. And so this is a really new field, and it's pretty new to have criminal charges for environmental damage in national systems. So it's really evolving, and we need to see more. I think I'll just leave it at that question.
Yeah, about the question from to combine the different incidents. I think that I would answer maybe in a strange way, but it's about methodological approach. I used to apply the in my experience in environmental audits, like 3 elements. It's like going to make site visits, to interview people at the site, and to look into documentation, analyze this documentation, right? This is like typical common practice for any evaluation, let's say, yeah, that audit is. And I would think that it should be also applicable in the case of this incident. So this, in this regard, like Robert is mentioned already, we need to consider scientific opinion. So if we do all these things like by applying approved by Ukrainian government approach, we need to ask scientific people to say, is it possible to evaluate that these 11 incidents is one area of damage? Then, of course, we can claim these 11 incidents all together. If not, but it doesn't mean that we don't need to spend time, efforts, and evaluation for each incident, you know. But it's a good question, and it could be combined like typical incidents, especially if it's happened in nearby area to each other.
I think my answer would be is it depends. I think if you're talking an individual chemical plant that's been destroyed and was released particular substances, it'd probably be difficult to abstract to a broader population. If you're talking loss of farmland due to anti-personnel mines that no longer be farmed, I think you could do it there. But when I think about bellwethers, I think about proving a very specific harm and a very specific damage, so that you have everything lined up and you have the highest probability of success. You know, I think one of the, riffing off something Cymie said, and one of the questions, I think one of our challenges in terms of getting these claims queued up in the process with other claims is convincing various authorities that these changes have real implications in human well-being. So it's not that someone died in the war, it's not that a building was destroyed in the war, but it will have real implications for human well-being. And what we're doing is trying to put that well-being back. And so I think, again, within a context of very specific claims, you could show that because you can show real change in communities.
My question about losing personal protection.
Yeah.
Unsworth?
No.
No.
Okay, sorry. Any other questions? Yes.
Okay.
Go ahead.
Hello, my name is Cristina Parandi. I'm also from PAC, so also Iryna's colleague. I have a broad policy question because that's actually the focus of my work personally. If we look beyond the constraints that we are currently facing with regard to assessment of damage, but also putting on economic cost of the damage. So of course, there are a lot of constraints and not having international methodologies and that trustworthiness of data of the claimant, which is Ukraine in this case, potentially. If we look at that like beyond all of these constraints, do you think it's ever realistic to aim for having the international standards for assessing environmental damage, like for instance, taking into account all the principles that Robert has listed, and having something more universal so that we can speak about universal principles or standards or guidelines, whatever it can be, and what would it take to get to that point, again, being maybe more optimistic than being restricted by the current constraints. So that's the broad policy one. And another one about the potential of application of universal jurisdiction to handle the environmental damage claims. So for instance, using the national legislation of one of the states, which is more developed, let's say, when it comes to ecocide or environmental damage, to take Ukrainian claims into account. So one more broad question, one more precise. We'll be grateful for thoughts from all of the speakers who want something to say.
And Dina from the University of Hamburg and the Gromada project. Thank you very much for your very insightful presentations. You mentioned criminal proceedings and civil proceedings. Did you hear anything about the human rights fora that address possibly also environmental war-related damage? And second, based on the data and the evidence that can be collected, can you use remote sensing as well to look into the causal link? Like who has done the damage, not that there is damage, but also establishing who is responsible for the damage? Yeah.
Okay, one more.
Thank you for very interesting presentations. My question to Iryna, you're a special rapporteur on toxics and human rights. This question is more directed at Cymie. You talked about restitution, and I was wondering if you could unpack some thoughts on when restitution could become materially impossible, imposing great disproportionality, to use the language in the International Law Commission's article, and state responsibility for wrongful acts in the context that we're discussing today. Thank you.
Thank you. Interesting questions. So I think speaking to the international standards issue, what I think we can think about that for the long term. I think in terms of the processes, getting processes going to actually look at Ukraine's concerns, I don't think the timeframes align. The amount of time it would take to get agreement on international standards would be very challenging. I think if we look at the difficulties that the International Law Commission had in working with governments and getting responses at the Sixth Committee on its reports, different and bringing those views together so skillfully, we can see that that's a challenging process. And I think the difference between the different fora also exists for good reasons. I showed sort of 4 different ways that you can look at this really from the national, international, criminal, and civil. It would make it easier for collection of evidence to have universal standards, but they don't exist now. And I don't think it's realistic to think they would in the time frame that we would want to see these things happening. And I guess for universal jurisdiction, that's a broader question, and it's a bit out of my expertise because it has to do with nation by nation. But I think there is the potential. There's potential in arbitration. There's potential in other national jurisdictions. I focused on Ukraine, but I think there could be some other processes, and likely will be. I think, and to your question, I haven't really looked at the human rights fora. I suspect that you may have, and so it might be
Anything about it. I'm waiting for it to come
well,
up.
then Marco's maybe the person to speak to about that. But I think that is an interesting alternative because we've seen things evolving in some of those courts, especially the European Court, for instance, the European Court of Human Rights. And then, Marcus, is your question. I think in principle, so what we've seen, the experience that we have is very pragmatic. So the International Law Commission's draft articles on state responsibility say you can get satisfaction. That's like an admission. Yes, we were wrong. Big deal. If you care about restoring the environment, restitution might be like a remediation in kind, or compensation might be the financial. Here's the money, and hopefully the money, you got to use it now to restore the environment. So that's the way I frame it. I think we did see with the UN Compensation Commission, and we got into a little bit of this with Bob and I doing a back and forth on that in some cases there were alternatives to actually, like, where there was damage and in the coastal zone, and it really would be more damaging to go in and try to repair it, that alternatives were found. And we often find that, like in the United States, in these cases, they settle and you can come up with creative solutions like, well, if the coast is damaged, maybe you can do a pump out facility for bilge water. That's another impact on the ecosystem you're trying to protect. I'm not sure if that really gets at your question as an answer to your question. It's more maybe pragmatic and theoretical, but
One more thought on that. I think at some level, standards are really helpful because they help tell us ahead of time what we need to do. But when you ask a group of experts who generally are not practitioners to come up with standards, at least on the technical side, you wind up with a orthodoxy that can't be achieved. And so I would almost rather go in without standards and just use sound science, which provides us with standards, than have, some group decide what's acceptable and not acceptable in advance. Again, I think it depends on if we're talking standards for what's recoverable. That's one thing. If we're talking standards for what proof, I would worry about that.
Can I just interject here? If we had standards do you think it would be more likely to have outcomes where you were at the very beginning, you said you gave kind of two different valuations and then the court chose a valuation that was neither of those two. If we had standards and tried to impose orthodoxy, do you think we would get closer to influencing outcomes from the judges that are closer to your valuation?
Only if your valuation was the one that's more orthodox. I don't, yeah, I think it, standards from a technical perspective, I think can constrain us. And it's very hard to develop those in advance of actual cases and actual situations.
As a lawyer, I would speak from my legal tradition. I'm a common law trained lawyer. And so for us, we think it's better to have the law, you have a case in front of you, and you develop the law further by looking at what that law, which is kind of theoretical, actually means in the context of facts. So developing standards in advance, can create a straitjacket that might not.
I mean, an example in the US context is the Oil Pollution Act allows you to recover either the cost of restoration or the social welfare loss. There's actually no economic basis for constraining it to those two outcomes. It just is how they wrote the regulations.
Maybe to add about human rights in remote sensing, and we don't have such experience to find to look into the chain who caused this damage, but we have like an example. Here is my colleague from company Cruise Hans, Dmitry, and they exactly presented last week in Kiev the investigation, exactly what you are asking. They found people and all chain, how it happened with the exposure of them on Kakhovka hydropower plant. So there is a good example that we come to Dmitro and he could send you the link on the investigation. According to the human rights, currently our PAX team developed the new research on toxic remnants of war. And we just were talking about it like in April to integrate this part in our research in human rights. So it's currently on our agenda.
Some more questions. First.
Well, my name is Emma Hadrava. I'm from the Finnish Institute of International Affairs. Thank you very much for the very interesting discussion. This could be a really big question, but still going to ask it. Iryna mentioned that there is no kind of registry or repository for the environmental data of the harm that has been observed. So what is the main reason for the non-existence of such a thing, and what would it take to develop a registry or something like that? Yeah.
Thanks. Thank you. And there was a question behind there. Go ahead.
Bob, you mentioned communal culture, like loss of communal culture or human well-being. These are more difficult claims to take into court. And I was wondering if any of the presenters know of any examples of where something like that was diverted and maybe creatively taken on and something good came out, like comparing it to a criminal case that diverted into mediation or something like that. Just curious as where some of those cases that might fall through the cracks lie or go.
Thank you very much. Emily Christie. I work for the Halo Trust and humanitarian landmine clearance organisation. So we currently have quite a large presence on the ground in Ukraine conducting clearance activities. And kind of related question to the one from the far side of the room. So talking about registering and recording data on the ground. Do you see that there's a role for kind of frontline humanitarian or civil society organisations to contribute to that process, particularly when it comes to ground truthing? And if so, is there a mechanism in place or one that's historically been in place in other conflict contexts that could be drawn on in this particular context?
Thanks.
Just wondering, from an assessment and from an evaluation perspective, how do you consider kind of the immediate effects on the environment and the long-term effects?
Technically, or
Well, I mean, in the moment, it looks like the damages are this, and then 5 years later, there may or may not be healing, there may or may not be new damages. 20 years later, you may see genetic things coming up that you had not seen earlier.
I think about environmental effects, it's special to me. Yeah, I mean, we normally use like identification like acute effect that we can see visually, yeah, and long-term effect. For example, a simple example, yeah, exposure in a populated area, it's acute effect, like with all this air pollution. And the long-term effect, it's like this depleted uranium fields. We can learn it from previous armed conflicts. And what we do, we are learning from previous armed conflicts, like in dynamics of health effects with people. Yeah, we can see it in this orange agent, what is going on, still going on with the US military people. So yeah, that's evaluation done based on toxicological profile and associated health effects.
So on Carl's question, so at the UN Compensation Commission, we had this problem because it was 10 years later. And the approach there was really, and if I need my memory jogged, but you can feel free to intervene, Bob. But I think pretty much the approach was to look at what were conditions at the time that the claims review was being done, as opposed to going back. There is this concept in the US for natural resource damages that you can have interim damage. Say for 10 years you can't fish in a damaged area, then there's some kind of compensatory mechanism. I think given the scale of damage here and the difficulties of actually dealing with this, I would be surprised if that came into play. But there's this other aspect which both is raised by Carl's question, answered by what Iryna said. The way we dealt with it there for the public health impacts was to provide funds for, and this was done through the governing council's rules, that this is what we were able to do, was health screenings for people. So that's not a complete remedy. Obviously, if you develop cancer 20 years later, to find out that you have cancer is hardly a remedy, but it was something, and it was a way to put it into the process. Let's see, I guess the other questions we had was the registry for evidence, the loss of communal culture. I'm not aware of the kind of diversion that you suggest, but it's an interesting idea and sort of flows into maybe other peace building conversations that people are having this week. If these legal processes can't fully resolve things, what else is there? And again, I think the landmine clearance question is, I guess I did have one comment on that question, which is about the role of non-official parties, if you will, providing evidence. If the evidence has all of the criteria that Bob has described, like the metadata and stuff, it can be useful. But if it's in other circumstances, we've not always found, if it wasn't collected for the purpose of the litigation, it's not always that useful. That's really, but I gotta really qualify that.
We would never turn down data. Data are useful, but I think having some standards that provide things like evidence of the day and time. The challenge is that, you know, as humans, we're going to be attracted to the thing that's most obvious. So it's not representative of the harm. It's specific to that harm, and so that's probably the biggest challenge. I think in terms of the effects on communities, I would look to indigenous claims, and I think there have been some successful examples of indigenous claims being adjudicated to get to a better situation. One of the challenges of war is displacement. So if a certain region of a country has a certain culture, if you've displaced peoples, that's a bigger effect than the environmental effect. So can they not return? And therefore, what happens to those cultural practices? So in terms of immediate versus long term, I think there's a science question here, which is, do we know what the concentration is in the environment that causes an acute effect, and do we know what concentrations cause long-term effects, and you use that to establish cleanup standards. If you're talking about the recovery of the environment itself, the time is not on your side. If you think it's hard to go back and imagine what baseline was, it's even worse for looking at something 10 years later, because there's so many things will have happened that have influenced it. So yeah, I mean, the very nature of these claims is they're not adjudicated quickly, and that's a disadvantage.
Emma, could you please repeat your question?
Yes. So because Iryna mentioned that there is no sort of common shared registry for the data on the harms. So what is the main reason that doesn't exist, and what should be done to create one?
Good questions. Thank you. I don't know what is the reason why it doesn't exist still. I think that somebody should take initiative, and maybe Doug smiling, maybe he would do it. Different organization has their own databases, and I'm sure it's just this duplication, and we should check and we have one place to store it, that it would be helpful not only for awareness raising, but some claims purposes.
So we have time for a few more questions. You, Doug.
Hi, I'm Anna Madler, and I work for a private foundation in Stockholm, the Global Challenges Foundation, and I have two questions. The first one is whether you think the recent, or not recent, but the big push by some actors, including some states, to have ecocide as a fixed crime in the Rome Statute, which would help ensuring criminal accountability for such crimes. My second question is about the fact that the ICC ensures individual accountability and not state responsibility. And I wonder, are there ways to ensure state responsibility, for instance, at the national level? What are the kind of current governance gaps here, and could the ICJ play a role and so on? Thanks.
Partially a question, partially a response. So some of what we've been learning and experiencing with Ukraine around what kind of data can be collected, how remote data might merge with locally collected data, was some of the inspiration for the UNEA resolution, which passed earlier this year. And one of the opposite parts of that was to encourage UNEP and other stakeholders to develop a standardized guidebook for states and other stakeholders on how to collect data, both local and remote. And that is a process which will be running up until UNEA 7, which is in December next year. And so hopefully that may create at least some kind of reference guide for these kind of processes, with some degree of international recognition. the hope is that it will also be a living document, so developing along with technologies and methodologies. Yeah, but I'd be interested on something Bob's take on that in terms of what would courts need. Would that be sufficient for courts to be able to use that as a reference document? What kind of would VNet logo be appropriate for them, or would they need something else, or would it need to be tested in the courts of law?
Yeah, I think some standards on use of remote sensing would be really helpful. One challenge that we're starting to see is altered imagery. So that I think standards that allow for the determination of whether an image has been altered would be super helpful. The other questions I think were yours.
So yeah, on the ecocide question, I have to admit I'm personally somewhat confused about the use of ecocide in this context. My understanding of ecocide is that it was not really intended to be a war crime, that there is a war crime that addresses environmental harm, and it's rather an awkward beast that many of people in this room have written about critically. But I think it's not something that I would focus on in the international context, in the context of the Rome Statute right now. There's using what we have there, and I think Carl has also spoken in writing and in orally on the way other aspects of the Rome Statute that can be used. So I'd like to see the attention going towards bringing that to life and defining it. The individual liability, yeah, that's the problem with the criminal law. It's symbolic, but it doesn't get you the environment fixed. State responsibility is where you go to try to find money to actually repair what's been damaged. And there, the register of damage would be the vehicle for that. There may be potential through national processes in Ukraine, although the issue is always how do you access the money that is going to be your long-term goal. So you have to think about which transitional justice, which peace building process, which end of the war process. It's going to serve all the functions you want. Is it, if you want accountability, maybe criminal liability is the thing to go for. If you want to actually restore the environment, then maybe that's not the way to go. So that helps.
I would like to thank all of our speakers, and I would like to thank you for all your amazing questions. Thank you very much.
Sure, all three of them.
So sure. You do a big one.
Yeah, I can take it.
At some level, we're all 14-year-olds.
Yeah.
Stand in a crowd together.
That way Fred can point out his height.
Oh, maybe this way, because the
You said they'll make us look into your features.
yeah. You have that on your phone.
Okay.
Do you agree?
And on my board, please come up. I'll remember.
You have to live with everything, but I don't know. Yes, this is great discussion.
Yeah.
Did you see?
I think it's.
Just, because I,